Welcome to Garden Views, interesting conversations with interesting people who have done and/or are doing interesting things. So sit back and enjoy. Welcome everybody into Garden Views, and we're continuing our sort of military-related trilogy of topics. And this week we're doing security clearances. Our guest today is Troy Nussbaum. He's an attorney, again, one of those attorneys who answered my call of Gideon's horn there on the Maryland Lawyers Facebook page. So I can't thank all of those folks enough. They've given me so much content that I was really overwhelmed by the amount of people who said, yeah, I'd love to do it. So thank you to Troy. Troy, welcome on into Garden Views. And why don't you introduce the folks to yourself, your firm, and whatever you want to tell us about your background.
All right, Jeff, thank you so much for having me. Yeah, I was excited to see you reach out to the Maryland Lawyers Group and ask for people to come on. This is going to be my first podcast appearance, so I hope I don't end up doing too badly. But
you're going to be a star, kid, a star.
Excuse me?
You're going to be a star, kid, a star, I can tell.
Well, thank you. As you said, my name is Troy Nussbaum. I'm an attorney with Hinault and Cisco Law Firm. We're based primarily out of Glen Burnie, Maryland, but we do have a satellite office in Northern Virginia, where I currently reside. As you said, my primary area of practice is security clearances. I do touch on some public trust issues, which is more suitability and fitness, which I'm not going to dive too deep into unless we end up on some extended time here later. But for the most part, government security clearances, I represent people all across the country, sometimes the world, depending on where they're stationed. I run the firm with my two business partners. And we're thankful to still be running through the COVID era and still be successful and helping our clients. I actually started out doing security clearance work in 2013 as a law clerk for my firm. The senior partner at that time had been practicing it for several, maybe 2 decades almost. And he was a prior NSA employee. That's how he got into it. And when they brought me on as a law clerk, they started teaching me about that. I was very grateful to be hired on when I graduated law school after spending 2 years with them. And when he retired, I took over the practice, and we flourished since. So we're very happy to help the cleared community all throughout the United States and the world.
Yeah, I think a lot of people aren't familiar with the area. Northern Virginia is basically suburban DC, right across the Potomac. Obviously, that's the federal government. If you just go straight north, you get the NSA is there. If you go south, CIA is there. A little bit to the west, we've got Fort Detrick, which probably people remember from the anthrax scare days. They've got labs there. And even we have Aberdeen Proving Ground up here. So this corridor is deep in governmental facilities, and a lot of, obviously your CIAs and your NSAs are about as high as there can be, a lot of military. But there's also a ton of private sector contractors, independent contractors, subcontractors, former government employees who form their own businesses to sort of go back to work for the government, but not at a salary. And in this midst of it, there's, well, as far as I know, tons of different security clearance levels. I'm sure that there's not tons, but maybe if we just did sort of like, you don't have to go through every level, but what's sort of the lowest security level up to the highest, and and I don't know what does that mean? What comes with that? Like, who's the private who guards Area 51 versus the person who gets to meet ET?
Gotcha. So when it comes to actually the definition of security clearance, there's actually only 3 types. There's a confidential security clearance, a secret, and a top secret security clearance. And it goes in that level, with confidential being the lowest. There are different level of accesses that can be added on top of that. And they are going to be generally referred to as SAPs, SAP, Special Access Programs, sometimes also referred to as RDs, restricted data. And one of the most commonly known restricted data or SAP programs is SCI, which stands for Sensitive Compartmented Information. And the reason I say that's the most common is that you'll find people throughout the cleared community who are generally granted a top secret SCI access, which allows them to get that compartmented information that is specific to their position.
Right.
When it comes to Area 51 and who gets to meet the alien versus who guards the doors, I have yet to be privy to that information as to what special access program they're involved in. But, I also can't confirm or deny that place harbors aliens. So,
well, maybe we should use a more real world one. Maybe, access to the nuclear submarines location versus the sea patrolman who guards the gate to the base.
Understood. Yeah. So in general, anybody who's got access to highly restrictive information like that is going to have an SCI access or some sort of special access program. And special access programs there are a lot of them. They're called different things, and they generally come with different rules and regulations as to who is eligible to be included in that special access program and have access to that information. And that those standards are going to be set by the entity that's giving out that access. So there's just so many out there, even more than I'm aware of. Probably one of the most well-known ones would be a Yankee White access, which is granted to individuals who are stationed or have daily interaction with presidential offices or vice presidential offices. So that would be probably the most well-known one, I would say.
Would that be like an example of, you're elected president, you want to have your own people in there? Just not to pick a name, but to take a recent example, former President Trump would bring his kids in and then, Jared Kushner and give them security clearance. Would that be an example of one of those access, or is that different?
Yeah, presumably anyone who occupies a position within proximity to the president or vice president is going to be granted a Yankee White access. When it comes to the eligibility of those individuals around the president, that's a whole other story. But yes, that those individuals would, in general, have a top secret clearance with a special access program granted to them, being the Yankee White, in order to be in and around the president.
Yeah, and this is, I think, where it gets a little bit confusing because, again, most of my knowledge is, just from TV and movies, which is not knowledge at all. It's information, not necessarily knowledge. But, the president wants, let's just go with my Area 51 one. The president wants to know about Area 51, and the director of the CIA says, sir, you don't need to know that. It's classified. You don't have, I'm the president. You have all clearance for that. Is that a real thing?
Yes. And probably the appropriate term would be need to know. You don't have the need to know for that. It is, you see in movies and TV all the time, that's above your classification level. That's kind of, I'm going to say that's probably not the best way to characterize that statement. While not totally inaccurate, it's more, probably better to say you're just not entitled to that specific information. You don't have the need to know, because presumably people who are within spitting distance of each other and have the ability to talk about these subjects in just the broad nature would likely have some sort of top secret access, if not a special access program. But the appropriate way for those individuals to talk about it would say, I have access to this program, which you may not have. I have the need to know for that information, and you don't. And that's generally where that would come in.
Wow. There must have been some strange statutory scheme that led to that somebody sort of outranked a president. I mean, I'm not arguing with it or even against it. It just seems weird that somebody can say to the president who was elected, say, you don't have clearance for that, sir or ma'am.
Well, I don't have access to enough presidents to tell you whether that's actually ever happened, nor do I know, unfortunately, whether there is someone who can tell the president they can't have access to any certain information. I'm not sure there's anyone higher than the president when it comes to the executive authority of classified information. So, unfortunately, I can't speak to that one, that specific circumstance there.
All right, I'll find my mole one day. I'll find my deep throat one day and get to that level. Let's stick to the onion that you do know then, and so the security clearances. There's basically the three, and then there's the special access programs, often compartmentalized to your department or your agency, or I guess it can, I guess the higher your rank is, the broader it may be, but what's the basic distinction, if there is a basic distinction, between the three levels?
It's just going to be the level of information, for lack of a better term, just the classification of information you have access to. So confidential would be very, very low level information. Secret information would be, that mid-grade stuff, and top secret would be very highly sensitive information. The higher up you get on the food chain when it comes to clearances, or an SCI access or special access program, it's generally looked at as, you have access to more important and dangerous data. Dangerous in a sense of, if it were released, it could be dangerous to the the protection of national security.
And because of these SAPs, let's say maybe someone that's in the CIA and the FBI with the same security clearance level, because of their SAPs, they may have access to very different information that one might feel like they have access to far less information than, say, their counterpart, that they deal with on a day-to-day basis.
Absolutely. When it comes to those agencies that are different, if you have a top secret SCI access at CIA and someone else has a top secret SCI access at NSA, they generally don't have access to the same information, unless, of course, that information is shared across the agencies and is held within their compartmented access. But in general, there are people at these agencies who have to go, for example, an NSA employee who has to go get vetted by CIA in order to see the information that CIA is willing to release them to share across the board. So just because one person has a top secret SCI access at CIA or DIA or NRO does not mean they are going to be privy to any other agency's top secret SCI access at all.
And is that vetting, is that what the Director of National Intelligence's office is for, or do the agencies do it directly and only sometimes does it rise to DNI level?
The agencies are going to be vetting these people on their own. They are going to be the ones who hold the final authorities to who can and cannot see their information. Now, not to get too deep into the weeds, there is regulations that individuals can request, or the agencies can implement reciprocity when an agency, a different agency has investigated an individual to the same degree in which that agency would investigate that individual. They can choose to reciprocate that. And it happens and it doesn't happen.
How does this play in with foreign agencies? I mean, again, movies and TV, my biggest source of information. MI6, MI5, whatever, Mossad, whoever it is that we deal with it, obviously they have their own security clearances, but there's counterparts and whatever. How is the decision made who you share information with and how freely? I mean, at some level, I guess there has to be some discretion, but probably at the macro level, there can't be. I mean, you have to be boxed in by something until you get clearance, I guess, from a supervisor or whatever. I think my question's getting too long to be a question. So how is that handled on a general, let's just say, spy to spy, defense intelligence agency to defense intelligence agency level?
So, unfortunately, I'm going to be speculating a little bit in this answer, and I apologize about that. But my expertise doesn't really lie with
international.
I would presume the agencies responsible for that information would be approving the release of that information in the method approved to the international agency or organization or other nation's agency or organization, and vice versa, I would presume. But again, the spies, while we have represented a handful of spies, they generally like to remain hidden. So at least in my experience, they infrequently have security clearance issues. So these aren't really questions I get to ponder with them very frequently.
Understood. So it's not one of the things that they, like pretty much everything you can talk to no one about it except your attorney. But in this case, that's not even one of those exceptions necessarily, unless it's, I guess, directly relevant to the defense.
Even regardless of attorney-client privilege, these individuals, when they're granted access to classified information, when they're given a security clearance and become privy to that classified information, they sign an NDA. They still have an obligation, regardless of who they're speaking with, to ensure that that individual has the appropriate access to also converse about that information, and that it is only conversed about in an area in which conversing about that information is permitted. Sometimes that would be a SCIF, and the actual acronym eludes me now, but sometimes that would be a SCIF. Sometimes that may be appropriate government buildings, other appropriate government buildings. But in general, my clients cannot come to my office and discuss classified information with me, nor do I ask them. And I make sure to tell them that they shouldn't at the beginning of our conversations, because they still are under an NDA. They still are under an obligation not to disclose that information, and that could cause them further security clearance issues and could cause me a headache with whatever agency's information I have, and I don't want to deal with that.
Yeah, sure, of course. And if you felt like you had to reveal it in the hearing and they couldn't reveal it to you, then there's double trouble.
Yeah, and a lot of those hearings don't actually allow for discussion of classified information. I have not been privy to a case yet where I've had to be read on to deal with classified information. I have colleagues that have. I think it's called a limited security agreement, where the agency will permit the attorney to actually to view that limited scope of classified information for the purposes of their representation. And they would, of course, then also have to sign an NDA and make sure that information doesn't leave them or their office as well.
And there is vetting there. And the only reason I know this is because my old firm, and this is a story that the then partners used to like to talk about a lot, because I was, a young attorney then, probably, like 27, 26. They had a client that got electrocuted on a military base. And so they had to actually physically go there to do certain things, depositions, investigations, expert reports, and they had to get read in, and they had to have limited security clearances, and, they had the background checks and all that before anything could happen. So, this is probably going back to 1990, because it was before I came on board. And I have a feeling that it wasn't like 2 years before I came on board. It was probably like 10 years before I came. So it's probably mid 80s, late 80s. Anyway, not about me. Let's go to some of the brass tacks and some of the real basics. How does one go about getting a security clearance? And then how does their security clearance get increased? I mean, I assume some of it goes with you as you advance in your position, but what they say about assumption.
Yeah, it all goes back to that same phrase I was discussing earlier, the need to know. An individual has to have the need to know. So whatever position they've been hired into, whether it be a government employment position or a government contract position, to fulfill the needs of that contract or to fulfill the needs of that employment position, they have that is defined as them, that position having the need to know that specific information, whether it be confidential, secret, or top secret information, or a special access program, whatever it may be. And once they have been designated as an individual with a need to know, a background investigation ensues, which involves the individual filling out the standard Form 86 or SF 86, also referred to as the electronic questionnaire for investigative processing, or EQUIP, which is the form when it's done through your internet browser. And from there, that gets submitted, the background investigation begins, and the individuals, depending on what level of clearance they're getting, is going to depend on how in-depth the background investigation goes. And from there, after all the information has been developed, it's going to head over to the adjudication office, and they're going to make a determination whether it's in the interest of national security to allow or disallow this person to have that access, that level of access. The standard there is actually quite difficult. It's is eluding me at the moment, but I have it right here. It's
While you're looking that up, I just want to clarify one thing for the audience. I think it's part and parcel, but when we're talking about security clearances, we're talking about United States federal. We're not talking about the individual states.
Yeah, absolutely. United States federal security clearances. And I apologize for having a brain fog there when it came to the standard. But the standard is an individual must be found the individual's need for access or after the adjudication that it is clearly consistent with the national security interest of the United States. Any doubt whether it is clearly consistent with the national security interest is going to be found in favor of national security. So it's a pretty high standard.
Yeah.
The any doubt standard. So it can be relatively difficult sometimes for individuals to get clearances. There's a lot of other criteria, and I'm sure we're going to go into that here momentarily. But that's the basics of how an individual gets a clearance. We have people who reach out to our firm all the time, help me get a clearance, this, that, and the other. I wish I could. I wish that was what I did because I have a lot more clients. But at the end of the day, they have to have the need to know. They have to be sponsored by a government contractor or an agency as an employee to process for that clearance, and it must be found that it's clearly consistent with the national interest, and then they can have that clearance as long as they abide by the NDA and the other obligations that the individuals who have security clearances have to live by.
Let me see if I understand that. So if somebody applies for a job or a security clearance and it's denied, that's not where you get involved. That's basically full discretion of the government.
Well, that is when someone is denied or has a clearance revoked is where I get involved. I'm involved at the entire process from applicants to appeals, but that it is at the discretion of the government entity that is adjudicating clearance, yes, to determine whether that individual meets the standard. But once they are denied or once a clearance is revoked, they have due process rights, certain enumerated due process rights or established due process rights.
Oh, what you were saying earlier, though, is you can't apply for a security clearance for them.
No, not at all.
Okay. So if somebody gets denied, are the procedures the same for someone who gets denied versus gets revoked or I was going to say knocked down the level. I'm not even sure if that's something that happens. But is it the same, or are there different administrative remedies, legal remedies?
To touch on the knocking down is not like an adverse determination. It's you can go up and down as your need to know changes. But when someone is denied or revoked, the process does change depending on whether it's a denial or a revocation. But it does and it doesn't, because in some venues it changes and in other venues it don't. It doesn't, excuse me. As an example, and sometimes they're just minuscule, very minute changes. As an example, because my office is in Glen Burnie and I'm right next to Fort Meade, I do a lot of NSA-related work. When there is a revocation there, generally, for the most part, those revocations are related to employees. So the employees are the ones, or contractor employees, are having revocations. And in the processing of that, those individuals, their directions tell them to submit their written response. Gives them the option to send it in via email. Whereas contractors, when they have denials, which is generally the most work that comes out of the NSA is a contractor denial, they are instructed to mail their documents in via certified mail. Even though it's still the same adjudicated criteria and things like that. But I can't tell you why those two processes are different.
Well, probably because the email is on through a secure server, right? And whereas the contractor maybe not. That's all I can think of. That's all I got.
Not going to speculate on that one, but so that's an example of where there's a very minute difference. But for the most part, the processes.
There's no speculation. I'm sorry. It's the union. The union might represent employees and say we want to make life easier for the employees, but they don't care about the contractors.
Perhaps. I tend to think it's an efficiency standpoint where the government has an interest in expeditiously resolving cases of individuals who currently have access.
Yeah, that's good.
Versus, perhaps individuals who have just been denied, they say they can just take their time on that because there is no concern about what information they're currently privy to.
Right.
So, yeah, that's how that's different. But for the most part, when it comes to the actual process, unfortunately, it changes a little bit depending on whether you're, for example, a Department of Defense industrial contractor or a Department of Defense employee or an intelligence agency employee or contractor. The process has changed, but there is a basic outline of the process which was established in Executive Order 12968, which essentially provides the basic outline for what the due process rights are, and it being, the individuals who are subject to that denial or revocation are entitled to a comprehensive and detailed written explanation of the basis for the denial or the revocation. They have the right to get the records upon which it's been based, a reasonable opportunity to reply in writing and to request a review of the determination. They must be provided written notice of the reasons and the results of the review, along with written notice about their rights to appeal, and finally a final appeal, whether it be in writing or in person. And that's the minimum amount that they're entitled to by that executive order, which is, it's a pretty good amount of due process rights. Unfortunately, it doesn't always work as well as we'd like it to.
Is there any court that hears it? I mean, I assume these are hearing officers. There's probably administrative courts or some equivalent within the agency, and we'll get to that shortly. But can you appeal this to the court, the district court, or the federal court of appeals, or up to the Supreme Court, or is it's totally encapsulated within the security agency apparatus?
The federal government would like to believe that it's totally encapsulated within the administrative processes that are provided. I've yet to be privy to a case where an individual has filed suit or attempted to appeal this to a district court at the federal level. There are a handful of cases out there in which individuals have tried and have failed, most notably being the Department of Navy v. Egan. But in essence, it's an extreme uphill battle to try and get judicial review on something like this. Right. For the most part, individuals are provided the administrative processes. Those minimum ones I just mentioned, and however they're implemented is going to be different depending on who's adjudicating it. So as an example, for government contractors through DoD, they are given the opportunity to attend a hearing at the Defense Office of Hearings and Appeals. Their primary office location is located in Arlington, Virginia. Whereas individuals, employees, contractors at the NSA, their hearing is in front of the NSA Access Appeal Panel, which is a 1-hour panel they get with senior level NSA employees to make their case. They don't get to be actually heard in court.
Are these physical locations? Is this, if you're stationed or you work in Hawaii or San Francisco or Lincoln, Nebraska, do you still have to come to the NSA or this Department of, I forgot the
Office of Hearings and Appeals. If the Defense Office of Hearings and Appeals has a few satellite offices across the country, and I believe their documentation says that you are entitled to a hearing within 150 miles of your home. So they don't necessarily have to come to Arlington. They can elect to come to Arlington if they hire me or any of my colleagues in the area. The home office of the Defense Office of Hearings and Appeals is definitely where I'm most comfortable. But they also do, through the pandemic, they've done video teleconference hearings, and I don't think anyone's perfected that at this point, but that is still an option for a lot of people. I have clients hiring me from all across the country, and rather than making the expense to fly here or fly me there, we're doing those video teleconference hearings. When it comes to agencies like the NSA, you have the right to be heard in person, but you have to travel to Fort Meade or to Maryland to do that. That hearing isn't necessarily located exactly on Fort Meade, but it's very close. And it's just going to be different depending on what government agency you're dealing with. The process changes, again, from DoD contractors to DoD employees. We have the contractors are given a document called the Statement of Reasons, which is essentially like an introductory pleading, for lack of a better term, stating it's similar to a complaint, just stating the basic allegations the government intends to deny or revoke a clearance on. And that's going to be for the industrial people, and their response is looked at as a general pleading too. Whereas the employees get a narrative format statement. It's still called the Statement of Reasons, but it's written in a much more narrative format. Contains a lot more factual information. Sometimes it can be pages and pages and pages long. And when the employees respond in writing, that is looked at as their first level actual determination. It will be made in writing. Whereas the industrial contractors, even when they respond in writing, they still have the opportunity to be heard at a hearing prior to that first level determination being made. So how the executive order has been implemented throughout different agencies and for employees or contractors is different. And unfortunately, I think some of those processes are better and some are worse, which is difficult for the individuals who I believe have worse processes.
What's the typical duration between the initial hearing, whether it's written or oral, and a decision?
Again, that's going to be agency dependent. I'll stick to the stuff that I know the best, which is going to be the DoD and industrial contractors, DoD employees, and NSA work. It's a big bulk of my practice. So when you're talking about the contractors, from the day they receive the SOR, if they did everything as quickly as they could, and they get a 20-day time period to respond, and they can get some extensions, generally we do, but if they responded as quickly as they could, I'd say they can have a hearing within, as it currently sits, within 6 to 9 months. And from there, it's just how quick the judge can render a decision. And then if the decision didn't come out in their favor and they felt the need to appeal, that could go on even longer. But when I first started doing this work, I'm not going to speak for the actual agency themselves, but it took a lot longer. And leading up into the pandemic, they've done a really good job of shortening things. But I think some of the video teleconference hiccups and personal appearance hiccups really kind of messed some things up. And I'm not going to go too deep into all the timing processes for everyone else, but it's just agency dependent. It's different.
Okay. And how many levels of review are there, or is that also agency dependent?
So their individuals are entitled to 2 levels of review.
Okay.
The first written response, and when it comes to the industrial contractors, they get the written response and a hearing. And then if that doesn't come out in their favor, they have the right to appeal again. NSA, you get their first level as a written response only, and you have the second level appeal, the access appeal panel. And the DoD employees are going to be the written response only. And from there, if you wish to appeal, you can appeal to the Personnel Security Appeals Board for that division of whichever consolidated adjudications office you're going through. And I'm not going to get too deep into the weeds there, but or you can appeal to DOHA, and which is the hearing office that does the industrial clearances. They'll have a hearing and send a recommended decision over to PSAB. From there, there's a final determination. It just goes on and on. But yeah, in essence, there's 2 levels.
2 levels. So that's much less than most other routes.
Very, very long-winded answer to your short question. I apologize.
So that's fine. It lends credibility, and it certainly falls right into stereotypes of the government. There's a million different routes to get to the same place. I'm sure there's reasons for everything. So we have the 2 levels of appeal. Theoretically, there may be levels further through the court system, but you haven't seen any. This, I presume that the person who is, they're not the defendant exactly, the respondent, your client has a right to assert their Fifth Amendment rights, but I further assume that's pretty much going to automatically err on the side of national security, and they're not getting their job or the clearance.
Yeah, absolutely. They have the right to assert their Fifth Amendment rights. The government, in my opinion, still has to have sufficient reason to believe that whatever they're investigating is accurate in order to find against my client. But I can imagine if there's an allegation, even if I were able as the attorney of record to poke holes in whatever little evidence the government had and say my client did or didn't do something, if they got up on the stand and pled the fifth, I don't know how the administrative judge would make a determination on that.
Right. You basically have to win on whatever the equivalent is of summary judgment. That the government's pleadings were so flawed or full of holes that your client basically never really needed to say anything.
Exactly.
Okay. Well, so it's few and far between when that happens. Anyway, I just imagine that everything are on the side of national security. That would be sort of an easy one. So these folks, when they have lost or they've been denied their security clearance, I guess if they were denied it up front in application phase before they were working, they're not working. But if they are working at a lower clearance, but they're denied for a higher clearance, are they still working at that lower clearance, or are they more or less unemployed pending this decision?
Interesting question. If you have a low level clearance and you are sponsored then for a higher level clearance, and there's a pending denial, or even when there's a pending revocation of anyone's current clearance, it's going to be agency dependent as to whether they keep their access through the due process phase. Sometimes it can be suspended depending on the agency. Sometimes it's not suspended. I actually have a client right now who applied for a secret clearance and was very upfront and honest on everything they did with the application. And the application has a section that asks you for your drug usage in the past 7 years and other questions about drugs, if you'd ever used it while possessing security clearance, et cetera, et cetera.
So I assume that the answer to that one, or a good answer, is not, I can't remember all of that.
You wouldn't believe how often we have to argue that people can't remember all that, because sometimes the government really wants to get down into the nitty gritty. I was working on a case today where the government really wanted to get into the nitty gritty of a person's drug usage over a 15-year period.
Dude, I went to Berkeley.
Better yet, ask my client to remember what drugs they may have used 15 years ago and how often they were using it. But I have a client right now who has a secret clearance and applied for that clearance and was granted that clearance on the same information that they are currently being denied a top secret clearance.
Mm-hmm.
It's all drug use, which is unfortunate. Of course, we're going to fight it, but that's within the government's right to do that.
Yeah, different clearance, different information, different level of trust, I suppose. I mean, yeah. I imagine that probably happens quite a bit, especially depending on what agency they're in and what compartment they're in, even more so.
Yeah, there is a uniform criteria, Security Executive Agent Directive 4, which is meant to be the uniform adjudicated criteria for security clearances. So we would like to see, if I can get my client cleared through DoD industry for a secret level clearance or top secret level clearance, I would hope that an intelligence agency would make the same determination. They do have to take into consideration the higher level of access and things of that nature, but it can be very difficult to find that agencies tend to make different determinations on the same fact patterns. It can be more difficult to win the same case at a different agency. And then, it makes sense to a degree in when you think about these agencies have to take into consideration what the agency does. So if an individual has a history of engaging in serious criminal behavior, while they may be clearable at one agency, they may not be clearable to an entity within the Department of Justice because they are charged with implementing the crime, implementing the laws of that state. So it can be difficult in that regard.
Yeah, there's probably a difference for a contractor for the Department of Commerce than there is for the drug enforcement agency.
Absolutely.
Yeah, I mean, it makes sense once you think about it. We were talking pre-production a little bit about sort of, NDAs. I was using my Area 51, my favorite little example, of course, just because everybody knows. All around the world, if I say Area 51, people know what you're talking about. But, so you swoop in, you secure the area, and you've got all the privates and the corporals there as well. And and I asked you, I'm like, yeah, how do you keep those folks quiet? I mean, they can't possibly have the same security clearance as the colonel or the general or whoever, or Alan Nyack, who shows up. And you said, well, they all sign NDAs. So those NDAs, I guess they're lifetime?
Yes.
And do they also inure to the heirs and beneficiaries and assigns of the estate?
Well, I haven't seen one that could take that exact language, but considering the NDA prohibits the individuals from even telling me, their attorney, it shouldn't have to necessarily apply to their agents and assigns and their estate.
So pillow talk, if you write a book on that, that's bad.
Yeah, pillow talk. Unfortunately, it happens.
I'm sure.
Unfortunately, it happens. But they are prohibited from doing so. The disclosure of classified information, it does happen. I can't speak to the frequency in which it happens, but there are methods for individuals to protect themselves and their clearances if they were to do that, and to help protect the information, mainly being self-reporting, which becomes another requirement of individuals with access to classified information. They have obligations to self-report if they've disclosed classified information, amongst many other obligations of use of drugs, or whether they feel like they've been approached by someone engaging in espionage or someone attempting to pressure and coerce them. Silly things. I'm not going to say silly, but financial matters. Having to file bankruptcy, having a debt go over 120 days delinquent, things of that nature all have to be self-reported, amongst a myriad of other things, which can be found in Security Executive Agent Directive 3, if anybody's interested.
What about if a man or woman way out of your league looks like they're interested in you at a bar, and there's no reasonable way that should happen?
Well, my wife will want me to say that I'm going to leave and go home. But
just the fact that you've been targeted, do you have to report that?
If you believe you've been targeted, yes, you should be reporting that.
Now, I only mention this because this was part of the plot of the show Condor this year, which is sort of like Homeland, and the guy got drawn in by the Russians, when he was in the CAA liaison at the Greece Athens desk, and beautiful woman approached him, and and then the next day his boss goes, "You going home?" He's like, "Why?" He's like, "The woman." He's like, "The woman." He's like, rookie mistake.
I would say that show is correct. I mean, that would be a rookie mistake. I feel like that's a very common way. While I have no direct knowledge of that, it would appear to me that to be one of the most common ways that individuals are approached by nefarious actors.
I would think it seems rather obvious and efficient as well. All right. So that show's pretty well produced. At least it seems like it is. It's Andy McCarthy is the director. The folks at Homeland. I don't know. I've heard a lot of experts on TV say you'd be surprised how close some of those shows get. So I'm thinking that's one of them. All right. So we have the two levels of review, decline and revocation. While there's differences, it's more or less the same procedure. It's still those two levels of review, correct?
Yes.
Okay. All right. So forgive me because I forget the details of these specific cases, and you may not even know about this. This may be beyond the four corners of what your practice is, but I always get sort of confused between Julian Assange, Snowden, and that woman who released things. I think during one of the wars recently. I believe she was trans, and that's why I remember her, because that was part of the story. and she served some time.
You referring to Reality Winner?
Oh, geez, I don't even know. If I remembered her name, I would have just used that description, which could get me canceled. Even though, I mean, that was not part of the story, but it was an easy identifier because I think when she did whatever the offense was, I'll say offense because she was convicted, though a lot of people, I think she was a he then. I think she's now a she. I think she's transitioned. So, Assange and Snowden, one is WikiLeaks, the other isn't. And I'm not even sure if this is security clearance issues or hacking. And I mean, obviously all involves security, but I don't know if any of it is stuff that's part of, theoretically your world.
It's part of my world because of the waves that, the major security concerns and self-reflection that the government had to do as a whole, based off the actions of Snowden. Anytime there is a compromise of information, especially major compromise of information, I expect that our government would take a long look at the mirror and figure out how to make sure not to happen. That's not going to happen. And I believe that's what occurred after Snowden happened, for lack of a better term there. But it's left waves for many people in the industry, made things very difficult for them. I've been told before that inside the agencies and buildings that Snowden had access to, they were replacing technology down to Ethernet wires.
Wow.
Anything that he touched. I have no assurances or information to believe that's false or true per se, other than it's just something that's told to me. But it's made it difficult for individuals who have hiccups, especially when it comes to compromising classified information. I've represented an individual who made sympathetic statements towards Snowden, and this individual was very interested, but it didn't stop that from being the sole reason that he was denied clearance, which is well within the government's right. I don't believe anybody should sympathize with that man. I'm not saying my client was right to do so. I think he was wrong to do so. But I don't think that individual meant what he was saying.
Right.
And that's the unfortunate part. So, it's made things very difficult. I don't know, the whole story per se, I'm not familiar with the whole story as it relates to Snowden, but he's a bad man.
Does your firm ever get involved in the criminal defense when it escalates to something where there's a criminal charge, or do you have, specialists in that area that handle that kind of defense work?
So part of doing this type of work is avoiding, to the extent that we can, individuals getting charged with a crime. Any individual I've represented has yet to be charged with a crime. I'm hoping to keep that going for quite some time if I can.
Yep. Fingers crossed.
But yeah, in the event someone were to be charged with a crime, we're going to be referring that out. That's not going to be my area of expertise. And we do have a number of colleagues that work both in the security clearance industry and in the criminal aspect of that to represent people. I would say most notably, the crime individuals do sometimes get charged with is falsification of the official document, the S-86, providing inaccurate or false information on there. And the specific crime they get charged with eludes me, but it is related to that falsification or omission, provided it's intentional. And we have seen individuals charged with that crime for doing that, and which is why honesty is always the best policy to begin with, no matter what you're doing. But especially in the security clearance world, the government is much more likely, even if they were to deny you today for the information you freely and your security clearance application that made you ineligible, you are more likely to get a clearance 1, 2, 4, 5.
Actually, I sort of lost you. If you could just repeat that, maybe get closer to your mic and repeat what
Sure. You are an individual who is honest on their security clearance application and still discloses information that may be that may result in a denial of their security clearance or a revocation of a security clearance is much more likely to get a clearance in the future because they were honest. They have additional time mitigating whatever the issue was that caused them to be denied or have their clearance revoked, versus an individual who lied about it.
Sure.
Because then they have the conduct and the falsification. It makes things much more difficult. It's much harder to mitigate and more difficult for an individual to obtain the clearance.
Right. Short-term frustration, but they prove themselves over the test of time, and they earn it with time. So they may not realize they're building equity, just like when you pay down your mortgage. You don't feel like you're doing it, but you are. Because I am so ignorant on the subject, is there anything that is essential, critical, or important that I should have asked you about, but I didn't just because I simply don't know enough about the subject matter?
I guess, there are just a few things or maybe 1 or 2 things I guess I will mention. When it comes to adjudicating a security clearance, there is 13 adjudicative criteria. I'll list off some of the more popular ones, shall I say. Financial considerations. So we see individuals denied clearances a lot or having their clearance revoked because they have collections accounts or charge-off accounts.
Child support?
Child support, if you're not up to date on your child support, if you fail to file your taxes on time, if you fail to pay your back taxes as agreed or attempt to pay them at all, financial considerations, that guideline within of the 13 adjudicated criteria, in my experience, is probably one of the most alleged guidelines for individuals to be denied or revoked a clearance. But there's also the alcohol consumption guideline, which is pretty self-explanatory, drug involvement, substance misuse, which is going to cover misuse of others' prescription medication, which is something that people don't generally tend to think of. Of course, criminal conduct, handling protected information, sexual behavior, things of that nature. So there is the 13 adjudicated criteria, and actually the Security Executive Agent Directive Force, acronym, I call it SEAD, SEAD 4, has all that criteria in there. It's not that long of a document. People can read through it and get a better understanding of this. Once it has the concerning information, what I refer to as an aggravating condition, whether something exists, it's the aggravating condition and what information can mitigate that. And that's at least the stepping stone, probably the first stepping stone for arguing a case like this and representing a client. In addition to explaining the whole person concept, which is the second part of the analysis after the adjudicated criteria. I'll say probably one thing we didn't touch on, which is an interest for a lot of people, is polygraphs. You're going into these intelligence agencies or sometimes even the military or any other government agency, they may require a polygraph as a part of granting access to a certain level of information. And in general, there's 3 different types of polygraphs. There's the counterintelligence polygraph, there's the lifestyle polygraph, there's the full scope polygraph, which mixes the 2. So you get both at the same time. And it can be extremely burdensome because it's not used as a tool. In my opinion, it's not used as a tool to effectively figure out whether people are lying. It's used as a means of coercing confessions. So, we see people coming out of some of these intelligence agencies that implement these full scope polygraphs, admitting to things in a coerced confession, I would say. At least that's what my clients are telling me. Admitting to things that are not accurate and being denied clearances for things that are not accurate. And unfortunately, when they go into a full scope polygraph, it's outside the scope of information that would generally be investigated as part of a background investigation. Because instead of having a question on the background investigation document that says, have you ever been charged with a crime? Have you ever been charged with a felony? Have you ever been charged with a misdemeanor in the last 7 years? Have you ever been charged with crime involving drugs or alcohol, those types of questions. They may ask you, have you ever committed a crime, even if you've never been caught? Have you ever committed a major crime, even if you've never been caught? And we've had clients admit to things as silly as stealing a candy bar from a grocery store, 15 years ago. While that may not preclude an individual from getting clearance, the more major things that they do admit to can end up getting people in hot water. So it can be, the types of things that people end up bringing up in those polygraphs, prostitution, that's where the sexual behavior guidelines really come in, and even more nefarious, awful conduct sometimes that individuals have engaged in. And again, sometimes people are admitting to things that aren't true. And there's a line of questioning that government goes down that I think is not a great line of questioning, and unfortunately puts people in a corner. They're not prepared to defend themselves. They think they're in a happy-go-lucky conversation with people, and they're not ready to be backed up against the wall and told that they're lying about this and to admit that they did X, Y, and Z. They end up doing it just to get out the word. So it can be difficult.
Do you have to submit to these polygraphs when you're applying for the security clearance, or you're being considered for an increase in your clearance?
You do not have to do anything.
Okay.
Anytime you go in for a polygraph or psychological evaluation, it's optional. But know that you're not going to get the clearance. You're not going to get the level of access you're seeking if you don't do it and you don't complete it to the degree that the agency wants you to do. So we have people that will call us and say, "Hey, I'm concerned because I'm supposed to take a full scope polygraph, and I want to talk about X, Y, Z things, but I think are going to come up in my background." And we've had to tell people, "Hey, it may be best if you don't go for that. That may be something you don't want following you, because it could result in a denial now. And even if an individual goes to get a lower level clearance that doesn't require a polygraph in the future, those records can still follow throughout their future. So it can be very difficult. But
stick with your bird in the hand. Stick with the job you got now.
Exactly. So it's a hard. It can be very difficult sometimes to advise people on what's in their best interest. Yeah, so that's the polygraph situation there. I think we've covered quite a lot today.
Good. That's what we're supposed to do. Well, if there's anything that you think that we've forgotten, you can circle back and I'll loop it into another show or something. And maybe if you can, I don't know if the criminal defense aspect of it is enough of a topic to, if you would refer one of your colleagues to me, it might not even be something that's interesting enough, or they can talk about, but something to think about. But yeah, why don't you tell the folks where they can find you, assuming you want to be found?
Sure. So if you're looking for me at my law firm, you can find us at www.hsclaw.com. You can find me on Twitter. I believe my handle is Nussquire, Nussquire. I thought that was a pretty fun way to make a Twitter handle. And I'm also on LinkedIn, and feel free to add me there. I'm happy to be a resource for people. I also give a few talks here and there at different seminars or whatever it may be about security clearances as things go on. But yeah, that's where people can find me, and people can reach out. I'm happy to make connections and happy to get to know people.
All right. Well, very good. Thank you so much for this education. I think we did it in just about an hour, which I think is amazing given my meanderings and the breadth and scope of the topic. One day I'll find that Area 51 person, but not today. Not today. All right, folks. Thank you for tuning in to Garden Views. Please check out the show if this is your first time listening to Garden Views. Please subscribe to Garden of Doom, because Garden Views shares the feed with Garden of Doom, which is my master show, which is more of a variety. But I promise you'll find things that you like there also. Garden Views is sort of just my straight mainstream stuff. Lately, a lot of legal topics, but certainly not exclusively. So check them both out. rate them, review them, 5 stars, give referrals, share. We're sort of algorithmically challenged, especially with Garden of Doom's variety on there. So we definitely rely upon referrals. But check it out, subscribe, and hopefully we will hear from you next week. Thank you again, Troy, for joining us.
No problem. Thank you, Jeff, for having me. It was a fantastic time, and maybe sometime again in the future. Who knows?
Excellent. All right. Take care now.
You too.
I went to Paris and France, found a little romance. She was walking down the boulevard. I know I should have been good. I never thought that I would. Double cross and baby, cross my heart.